This is Advocate REHAN NARULA in front of you, and today we will be talking about an important issue. What happens here? A taxpayer, when he appeals to the first appellate authority on the adverse order which he receives from the proper officer, but while filing that appeal, he has to deposit an amount of 10% of the tax amount as pre-deposit, right? This is the normal process which a taxpayer follows. But now, after fighting the case for now 2 to 3 years or more, he receives an order in favor. Congratulations, right? And being very happy, the taxpayer applies for the refund of the pre-deposit amount which he deposited at the initial stage. But he gets a shock by the department, stating that your refund application is now time barred, right? Now what happens? The petitioner approaches the High Court. The case which I'm talking about is the case of GTL infrastructure. The petitioner here approached the High Court of Jharkhand, in which he stated that I have deposited the amount of pre-deposit and I have received the order in favor now, but while I'm filing the application for refund, it has got rejected and deficiency memos are issued stating that your refund is now time barred, right? The petitioner contended that withholding the refund of the pre-deposit would be hitting the Article 265, as it states that no tax shall be levied or collected except by the authority of law, right? The petitioner here sought quashing of the deficiency memos and direction for the issuance of refund. What was the issue here? The issue that whether the limitation period prescribed in Section 54 of the GST Act is mandatory for refund of pre-deposit after the appeal is allowed in favor of the taxpayer, right? This is the issue. What did the court held here? The court here held that this particular issue is not now res integra. That means that the division bench of High Court of Jharkhand has already taken up this matter and decided that withholding this refund of pre-deposit would not be sustainable, right? That the court held that the refund cannot be retained by state or center, and taking into consideration the language of Section 54, it states that taxpayer may make an application before the expiry of 2 years from the relevant date, right? The court opined that the word may has been interpreted by Honorable Supreme Court in the case of Muskan Enterprise, and the court relied that the user of the verbs may and shall in a statute is not a sure index for determining whether a statute is mandatory or directory. The court has to look up to the intent of the lawmaker to understand the meaning of the word, right? The court held that taking into consideration the refund of statutory pre-deposit, it is a right vested. It is a right of the taxpayer to get that refund, irrespective of that time barredness of the Section 54. And there's no reason to say that the pre-deposit made by an SSE can be forfeited by taking the aid of Section 54 by the department. And if the department withholds the amount of the petitioner, the pre-deposit, it will be undue enrichment. This particular judgment is very important, and if you are facing similar issues that you have received an order in favor, right, and while you have applied for the refund and your application has got rejected, you can approach your jurisdictional high courts, and you can use this judgment which you will be getting in the description box, the newsletter. You can quote this judgment as a precedent, as a persuasive precedent for your jurisdictional high courts, and get an order in favor, right? So this video was about this only. Thank you for watching this video, and we'll meet in another one. Thank you.